One of the primary questions that we're asked frequently in the course of a week or a month is, do I have a case? I've been involved in an accident and I need to know whether I should hire a lawyer and present a claim for the damages and the injuries that I've suffered. We have found that there are a number of broad categories that just about every case will fall into. And this is the methodology that generally I use to screen those cases. Recognizing that for every 10 calls that come in, probably only 1 or 2 would actually result in a file. And as I go through this explanation, you may understand why. The analogy I'd like to give you is a device. You maybe have seen it used in a bank where someone will have a large collection of change, and it has to be rolled, and the device will separate it into pennies and nickels and dimes and quarters. The analogy is fitting to the kinds of cases we receive because by the end of our conversation we have also fit them into categories like pennies and nickels and dimes and quarters, and that doesn't relate to the possible value of the claim but the category of the kind of accident involved. So one of the first questions I like to ask is whether the person calling in believes that someone else is at fault for this accident. This is based on the principle in law that there has to be a tort of negligence involved for a claim to properly lie if someone has neglected to carry out their duty in an adequate fashion. The tort of negligence involves 3 components: a duty of care, a breach of that duty, and damages that flow from that breach. So I asked the client, why do you think the other party was liable? Someone could have fantastic injuries, but if someone is ultimately not at fault for causing that accident, there is no claim. So in a game of baseball, ultimately you want to cross the home plate to score a run for your team. You've got to get on base safely, and if you don't get to first, you certainly don't get to progress further along the path of the bases toward home. So if there is no fault, no matter how serious the injuries are, there's no claim. Okay, well, let's say that there is liability that is reasonably expected in the omission of the defendant who caused this injury. Then we ask the nature of the injuries themselves, because sometimes it's a good news, bad news situation where someone has established fault, there is liability, but the injuries are very minor. Someone may have an injury that heals in a matter of days, maybe a month or 2, but within fairly quick fashion, the person is back to feeling the way they were before the accident, something that doctors will refer to as returning to pre-injury status. In other words, your healing is complete, you're just as good as you were, you're fit to go. It could be good liability, but your injuries just wouldn't be worth a lot of money, particularly if you didn't suffer any absence from your place of employment or didn't run up medical bills that weren't otherwise covered. So the second kind of call is one where there's liability but the injuries are very minor. The first kind of call is one where there could be terrific, serious injuries but no liability. The third category of calls is one that a lot of people's fact situation will fall into. And that's one where there is a good case of liability, but we just don't know how serious those injuries will be, nor the extent of the damages that would flow from those injuries. And there's a number of reasons why most cases will fit into this third category. For one thing, in terms of the percentage of calls that we receive, there's not a lot that involve horrific injuries like brain injury or paraplegia or a serious spinal injury or death. Those, of course, tragically happen from time to time, but the majority of cases involve more mundane, minor injuries. The legal process cannot run ahead of the medical process. In other words, until you can quantify a claim and until you can determine its viability, you really have to know how the medical process is going to play out. Because generally you can't assess a claim accurately until someone has reached what doctors refer to as maximum medical recovery. In other words, that you have healed and you're as good as you're going to get. At that point in time, we have a better idea of being able to assess a claim. And sometimes it's impossible to know the extent of someone's injury. Someone could have a rear-end collision in a car accident and have sustained a whiplash injury to their neck, what's called an acceleration-deacceleration syndrome. But some people will respond within days or weeks to such an injury, and others, it could take years. They could need surgery. They may never fully recover, and that can have life-altering consequences. Often it's hard to tell early on how someone is going to respond to the trauma of a accident. Age plays a factor. Someone's pre-morbid health that they had before the accident plays a factor. The emotionality of the accident victim is important to keep in mind. Some people are emotionally fragile and become depressed and suffer from mental health disorders more easily than other individuals. Some will find the traumatic event so troubling that it will result in a diagnosis of post-traumatic stress disorder, where people will have unpleasant flashbacks of the event taking place over and over again, and it can cause a multitude of health concerns. So how someone responds psychologically to a physical injury is very different from one individual to another. So this third category of injuries is hard to assess because there's good liability. That's reasonably well established, but it's uncertain whether the injury will persist over time and to what extent it will be a serious disruption of that person's life. So in summary, there's three different kinds of calls we typically have, and most cases will fall into this. One is a very serious injury, but no liability attached. Or it could be a more moderate injury, but in any event, liability is very much in question. Or it could be a situation where there's a good case for liability, but the injury is very minor, very transient, heals very quickly, and the case is just not economically viable for a law firm to proceed with. Or the third category, with the most frequency of calls, where there's good liability, but we're just uncertain the extent of the injury and how it will play out in the functional limitations of the accident victim. And then there's another category of cases which is quite different, where it's difficult to establish liability because it will take professional opinion to comment on the facts as to whether there's a case or not. Frequently, that will involve a call that we'll receive for medical malpractice, where someone will complain about the negligent act of a healthcare provider, resulting in damage to them or a loved one. But frequently with a case like that, partially because they're very hotly contested by the governing bodies of the healthcare providers, we need a report from a recognized medical expert in that field who can comment as to whether the standard of care was followed or not in the procedure that was done. And that often can cost thousands of dollars for such a report, and frankly, a lot of people just don't have the funds necessary to pursue such a claim. But having an expert's opinion on an important evidentiary point to help establish liability is crucial in some cases, because it's difficult to determine without that professional input what the standard of care might have been.